Good evening, everybody. Thank you again for tuning in to my weekly presentation, Legalese, where we discuss legal topics that affect Florida. With me today, I'm very happy to have a friend and colleague of mine, attorney Hunter Chamberlin. Hunter has been practicing criminal law in the Tampa Bay area for about 20 years now, and he is quite a constitutional scholar and very lucky to have him on board with us today. And we're gonna pick up sort of where we left off last week with Stand Your Ground. But anyway, Hunter, thank you very much for joining us this evening.
Well, I appreciate you having me on very much.
Tell us a little bit about yourself.
Sure. Well, I went to the University of Miami for law school, which I enjoyed very much. And from there, I went to the state attorney's office in Miami and was a prosecutor in Miami for a number of years, which was certainly a very educational opportunity. There's a lot of work for prosecutors in Miami, as you can imagine. My last year at the state attorney's office, I was invited to join a special prosecution unit called the Career Criminal and Robbery Unit. I had to interview to get onto this unit. It was a neat experience, but we prosecuted essentially the worst of the worst, what we call PERPs, which is prison releasee reoffenders, people that get out of prison. As you know what a PERP is, but it's somebody that gets out of prison and within 3 years commits a new violent crime, and what we call GORTs, or violent career criminals, which are people that have a history of violent crimes that are now yet again committing yet another violent crime. So I did that for a number of years before striking out on my own and moved to Tampa in 2005. I've been over here on my own essentially ever since. The large bulk of my practice is criminal defense.
What do you do besides criminal?
I am a portion of my practice is essentially outside general counsel for small companies that can't afford to have an inside attorney, a general counsel, but that I provide essentially litigation support for small companies and individuals that find themselves facing a lawsuit. Strictly on I shouldn't say strictly, almost exclusively on the defense side.
Oh, I see. Yeah, we have something in common. We both started at the state attorney's office. I started in Pinellas County under the late great Bernie McCabe, where I served my time. I really enjoyed that job quite a bit. Unfortunately, couldn't afford to keep it. Government work doesn't.
If it were too much fun, they wouldn't pay you anything.
Oh, but, most fun you'll ever have practicing law.
It absolutely is. And my advice is to any law school student working that's listening is, I know it's going to be difficult for a couple of years because you're not going to get paid a whole lot of money, and you're going to see all your friends at the big fancy law firms getting paid a lot more than you. But if you can do it for at least 3 years, go work for a state attorney's office. Be a prosecutor. You will have more trial experience, more legal experience than any one of your colleagues. It is absolutely worth it.
That was fantastic. I mean, just getting involved in trials. And of course, in the beginning, I had Judge Cadell, and he used to continue all my trials. So I used to have to run into Judge Freeman's courtroom and jump on trials there, but still managed to get a few dozen under my belt before I left.
It's great experience.
Oh, it sure is. It sure is. And Pinellas was a pretty organized situation over there, very well run office, and made a lot of good friends and colleagues. But one of the things in criminal law that we run into, obviously, when a person's been charged with a crime, they have certain defenses that are afforded to them. Now, I've heard you put this pretty eloquently, and I hope you will for our listening audience tonight. But if somebody's been charged with a crime, what potential defenses can they raise? Well,
what I tell people, and my book that I'm eventually going to write is a chapter, and this is a chapter in that book. So I'm copywriting it and trademarking it. But all joking aside, when people come to my office and say, I am being investigated for, or I am accused of, or I have been charged with X, my answer to them is any allegation of wrongdoing, whether it be an administrative complaint, a criminal statute violation, anything of that nature, there are only 4 defenses to any criminal defense. Jaywalking, first-degree murder, everything in between, there are 4 defenses. you're smiling because you've heard this. The first defense is it's a crime, but I didn't commit it. And the example that I use is a murder. There's a body on the ground with a gunshot to the back of the head. Clearly, that's a crime. The question is, who did that crime? The defense, of course, being, wasn't me. The second defense is sort of the opposite of that. The example that I use is DUI. The police officer stopped a car. In that car is me and nobody else. So that's no question that I'm the person. The question is, did I commit a crime? For example, DUI. The question is, was I driving under the influence to the extent my normal faculties were impaired? So those are the first two, sort of the most common. It's a crime, but it wasn't me. It's me, but I didn't commit a crime. The third is question of mental incapacity, which is what some people incorrectly refer to as insanity. That's one example of mental incapacity. But the defense is, I may have done it, and it may have been me, but because of a mental defect, I did not have the requisite criminal intent to formed, so therefore I can't be held criminally liable. And then the fourth is what some people refer to as technical defenses. I object to that term because I don't think the United States Constitution is a technicality, but that is, the police searched me in violation of my Fourth Amendment rights, or they seized me in violation of my Fifth Amendment right, or interrogated me in violation of my Fifth Amendment rights, or I asked for a lawyer and they kept interrogating me in violation of my Sixth Amendment rights, something along those lines, such that we have a basis to suppress evidence, thereby either causing a serious blow to or eliminating the state's ability to prosecute the case. So those are the four defenses. And when I get a new case, I'm listening to the narrative to figure out which of those, if any, may be applicable. And sometimes none of them are. Sometimes it's the person, it's a crime, they're not insane, and the police did everything right. And we don't have any of those four. And that leads us to the fifth, which I don't include because it's not a defense, but it's mitigation. It's, okay, you got me, but instead of giving me this punishment, give me this punishment. And here's a number of reasons why you, Mr. or Mrs. Prosecutor, should go easy on me. And that, in a nutshell, to vastly oversimplify my job, is criminal defense 101.
Very good. Now, if a person, if the state is able to put on a case, if it's able to create a prima facie case, if they're able to introduce adequate evidence to every element of the crime of which a person is accused. Oh, hey, Mike Isaac is here. Hey, Mike, how you doing? Thanks for stopping by. If a person is able to, or if the state's able to make a prima facie case, then the defendant may have to fall back on certain defenses.
Sure.
And why don't you explain to us how that works?
Well, so there's something in the law called an affirmative defense. What I not so sophisticatedly refer to as yeah, but. And that can be a defense in a civil case. It can be a defense in a criminal a criminal matter. And what I mean by yeah, but, let's use a civil example only because it's easier to conceptualize. A person comes along and says, I tripped in your store, you were negligent, and therefore I'm suing you. Well, an affirmative defense would be, yeah, I am totally negligent. I should have fixed that, but you sued me after the statute of limitations have run, so therefore you can't sue me anymore. So what a more sophisticated lawyer might refer to as admission and avoidance. That's an affirmative defense. You're admitting the facts as alleged by the plaintiff, but you still can avoid liability due to that affirmative defense.
As you know,
the criminal law as well.
Much of my practice is personal injury, which is civil. And whenever a defendant answers a complaint, we usually get a litany of affirmative defenses, sometimes as many as 15, 16, 17 defenses that are alleged in every case. And these have to be alleged in the beginning, at least some of them, otherwise they can't be, or they're waived.
Right.
Certain defenses aren't waived, but certain of them are. But we won't get into that. This will be on the scope of our conversation. So now we have affirmative defenses, the yeah, but, as you explained. And one of those defenses would be self-defense, would it not?
It would. So in a criminal context, think of you're charged with a battery or an aggravated battery. You hit somebody. So the affirmative defense was, yes, I hit them. And the definition of a battery is you use some sort of force, unwanted force, touching against somebody else. So the affirmative defense would be, yes, I touched that person with my fists. They did not want me to touch them with their fists. I committed a battery, except I have an affirmative defense in that I did so to protect myself. So you're admitting the allegations, but you're still avoiding criminal liability. That's the nature of an affirmative defense.
Okay, very, very well stated. We have somebody else checking with us. We have David Papa checking in. Dave is a law school student right now. He'll soon to graduate from law school and is going to be joining us in the ranks of practitioners very, very soon. Hey, Dave, thank you for joining. I used to work with Dave's dad, and I've known Dave since he was about 11 years old.
Nice.
So proud to see that he's getting ready to enter into the world as a practitioner. He was an amazing baseball player, but he's hung up the spikes and he has picked up the law books. Congratulations, Dave. Look forward to practicing alongside of you as a colleague shortly. But anyway, back to what we were discussing. So what I discussed last week was the affirmative defense or the immunity of stand your ground. The reason I kind of think it's a little strange to call it an immunity is because it doesn't really prevent prosecution, but it does have the capacity to put a stopper in it after a certain point once a person's been accused. So let's talk about that a little bit.
Sure. So let me, there is a difference though between immunity, as you know, and an affirmative defense. The stand your ground is not technically an affirmative defense because it, I'm pulling up the statute here, sorry, because it doesn't,
it's not a crime.
Stand your ground is you can still get a complaint filed, a criminal complaint filed or an indictment filed against you. But if you succeed on the stand your ground, that terminates the prosecution. Whereas an affirmative defense does not terminate the prosecution. It is up to the jury to conclude whether or not your affirmative defense has been proven. The jury doesn't get to decide stand your ground laws because it's a legal defense. So therefore only the judge makes that decision. So that's the distinction. But when it comes to what the stand your ground is, Florida has two separate statutes, 776012 and 776013. The 776012 is outside your house, and the 013 is within your house. But essentially what it says, and I have the statute, and usually the best place to start is right at the statute itself, but what's called the stand your ground law, a person is justified in using or threatening to use force, except deadly force, against another when and to the extent that the person reasonably believes that such conduct is necessary to defend him or herself or another. So it doesn't have to be just you. If somebody's coming after you, Chris DeBari, with using force, I can use force against the perpetrator to defend you within the parameters of the stand your ground. So it doesn't just have to be me. But against the other's imminent use of unlawful force, a person who uses or threatens to use force in accordance with this subsection does not have a duty to retreat, i.e. can stand their ground, before using or threatening to use such force. And then subsection 2 is the exact same. It just pertains to deadly force, so that a person can use deadly force if that person reasonably believes that using or threatening to use such force is necessary to prevent imminent death or great bodily harm. So those are the two stand your ground provisions. And
the stand your ground rule, 776012, mirrors pretty closely 776013, which
Correct.
Pertains to the castle doctrine, your ability to defend yourself in your own home. Correct?
Correct. Absolutely. And 776013 I will not read because it's a lot larger.
I read it last week.
What's up?
I read it to everybody last week.
Okay, so you remember then that it basically has provisions that if somebody is coming into your house that is not invited, then and it's not a parent and it's not a police officer and a whole bunch of caveats. But essentially, if somebody's breaking into your house, it is presumed that they have an intent to commit deadly force, and you are entitled to meet that deadly force with deadly force. Couple caveats, though. It's a reasonable person in that situation, not you, a reasonable person. So that's an important caveat.
Okay, and so that seems to be pretty straightforward, and I think people are mostly familiar with the fact that they have that ability to exercise that kind of force in their own home against somebody that would be attempting to force entry, remove somebody that they're not permitted to remove, and so forth. However, it seems to become a little more complicated when you take the duty to retreat or attempt to retreat away from somebody outside the home. That's sort of what Stand Your Ground does. Isn't that correct?
That's what it does. But remember, it has to be a reasonable person, not just the person can't stand up and say, I thought that the person was going to pull out a gun. I never saw a gun. He never threatened to use a gun. But I thought, for whatever reason, in my mind, that he was going to use a gun and kill me, so I shot him. In that case, you very well may have thought that, but a reasonable, sort of the normal person standard in that situation would have no basis to believe that you were in danger of great bodily harm or death. And therefore, the reasonable person wouldn't have thought it necessary to use force in that situation. There have been some famous examples, notable examples in Florida. There was the case in Clearwater last year, I believe, where an incident outside a parking lot where somebody used deadly force and the person ultimately died. The user of that force was put on trial for murder, and it was determined that the person did not have a justifiable and reasonable basis to use deadly force because he essentially was the perpetrator, and therefore his stand your ground motion was denied, ultimately went to trial. His affirmative defense of self-defense was not believed, or the jury didn't find it proven, and therefore he was convicted and was convicted of that crime and sentenced to prison.
Yeah, but this is America, right? Don't we have the right to defend ourselves wherever we are in America? Don't we have the absolute right to defend ourselves?
America is made up of 50 different states, and therefore 50 different, actually 51, probably more than that, but 50 different states and the federal law. So depending on where you are, the laws are different. For example, what you can do in Florida is with a gun, with a firearm, is vastly different than what you can do in your old stomping ground of New Jersey or my old stomping ground of New York. The gun laws, to maybe the understatement of the evening, the gun laws are very different in New York than they are in Florida or Texas or other places. So,
well, and you hit an interesting point. Now, the way that the stand your ground functions, it's required then that the defense make this motion prior to trial. So how does that work?
That's correct. So the way that a stand your ground process goes forward is, so let's say I'm the defendant. I have used force or deadly force against somebody, and so therefore I am prosecuted for some sort of battery or even attempted murder or actual murder, whatever it is. I am now charged with a crime, and I will then file a motion to dismiss that indictment or information, file what's called a sworn motion to dismiss, a C4 motion, asserting stand your ground. And what that does, if granted, it precludes not only criminal prosecution, but civil prosecution as well. They cannot be sued in civil court either. But I will file that motion. And the law has changed in a very significant way recently. It used to be the law that I, as the party invoking stand your ground, I, as the defendant, had the burden to prove that my use of force or deadly force was reasonable, such that I am entitled to the immunity and therefore can't be prosecuted. A few years ago now, a very well-respected jurist on the second district, who is now a federal judge, who I hold in very high regard, authored an opinion that said that that was incorrect, that an immunity is conferred on a person by the legislature, and therefore they have the immunity unless the state can prove that they are not entitled to the immunity. That's right. Was ultimately, that decision was ratified by the Florida Supreme Court, affirmed by the Florida Supreme Court. What that did was drastically change the stand your ground law, such that now all I have to do as a defendant is allege a set of facts to essentially make a prima facie case that I am entitled to the stand your ground law, the protections of stand your ground. It becomes the state's burden to prove that I am not entitled to the stand your ground law and to divest me of that protection.
And the judge will be the one to make that decision, correct?
And the judge makes that decision, ultimately makes that decision about whether or not the state has met its burden, not whether I've met its burden.
So it's interesting because a defendant may end up having a second bite at the apple if the judge were to deny his motion for stand your ground. He may go to trial and yet receive the self-defense instruction, and a jury may acquit him on self-defense.
Absolutely. So he can be tried. His stand your ground motion can be denied. The prosecution goes forth and the jury considers self-defense. Because of course the jury will not know that the defendant asserted a stand your ground motion and that was denied. If you've picked a good jury and have vetted them such that they're not aware of the facts and circumstances of the case. So the jury won't know that. So the jury will hear the self-defense argument from the defense and make a determination whether or not the defendant has proven the affirmative defense of self-defense.
Do you think that second prong could become problematic for a defendant if the case is publicized?
Well, that's certainly always a problem for defendants when there's pre-trial publicity. It makes jury selection, what we call voir dire, makes voir dire very difficult because you have to get people that have not heard about a well-publicized case in the news. And then that begs the question of what sort of folks are you left with that are so disinterested in the news that they haven't just inadvertently heard about this? Do you want those people on your jury?
Sure.
So it makes it very difficult, but that's the purpose of voir dire. And ultimately, sometimes you can't. Sometimes you can't get a jury because there's been so much negative publicity about the case in wherever circuit or county the case is being tried. Then you file a motion to transfer the case to a different circuit. Maybe we take it from Hillsborough to Orange County, where nobody's ever heard of it, and you have a more reasonable chance of having a fair, impartial jury.
Now, one last thing, we were discussing a little bit earlier how before we went live, how the Trayvon Martin case and how that case sort of brought stand your ground to the public attention, yet wasn't a case involving stand your ground.
It was not a stand your ground. It was a self-defense case, because the reason why that was not a stand your ground was because the officer was, from what my recollection was sort of lying on his back or lying in the car and had no ability to retreat even if he could. So it wasn't a case where he said, the officer said, I have the ability to retreat, but I do not have the duty to retreat, I am going to use deadly force in response to what I perceive as deadly force being used on me. It was deadly force is being used on me, and I have no ability to do anything other than defend myself. And so therefore I'm going to defend myself using deadly force, which ultimately, of course, was found to be, by the courts, was found to be legally meritorious.
Very good. Hunter, thank you very much for appearing on the show tonight. This is great stuff.
Well, this is fun. I dork out on this stuff. I love talking about this stuff.
That's one of the reasons why I want to have you on. We've had some great discussions and arguments in the past. Our arguments tend to be a little more political than legal, though. But at the end of the day, you know, we're all colleagues and we're all friends, and this is what we do. And
that's what the world needs more of, is political dialogue, the type of which you and I have, and not the rantings on Twitter, which is unhealthy.
Now, it takes a little bit of discipline not to express oneself, and sometimes practicing that discipline is very, very important. But anyway, just to the audience, thank you all for tuning in tonight. If you liked what you heard today, please feel free to share, smash the like button, and comment. I like your comments and your criticisms. In fact, sometimes I base entire segments upon that. And you know, the Stand Your Ground 2 episodes I've done so far were actually in response to a question about Stand Your Ground somebody had for me. I figured, why not talk about it? And then I'm happy Hunter had the time and was willing to come on and talk. He's an excellent lawyer. He's a constitutional scholar. And it was really great having him on the show.
Well,
and folks,
Thank you.
Certainly. And I guess you're going to, well, I'll talk to you later about it. But anyway, have a great evening, and thanks for coming on.
Absolutely.
Thank you everyone for tuning in.
Thanks, everyone, for joining.
Thank you.